Good day, Crime Talk aficionados. It's Saturday, January 29th. And what does that mean? It's the weekly recap of all the top stories from Crime Talk throughout the week, all located in one convenient location. Did the police lie? Barry Morphew, the Colorado man accused of killing his wife, Suzanne Morphew, on Mother's Day of 2020, returned to court Monday morning with a new judge presiding over his case. Now, Barry strolled into court just a few minutes after 8 a.m. alongside his two daughters. There's a motion to quash. And what were the matters that the court was going to take up? First was a motion to quash the internal affairs reports regarding the former Colorado Bureau of Investigation lead agent, Mr. Cahill. The judge said the defense is entitled to that information. Why is that significant? Well, Agent Cahill resigned from the Colorado Bureau of Investigation in December because of an accidental discharge of his weapon at his home. Now, in an internal affairs report that was done, and CBI told the defense during their investigation that Agent Cahill was not truthful during his testimony. End quote. Ouch. When your lead investigator is found not to be truthful, that's certainly going to help the defense. Why is that important? Well, because the defense is saying that Cahill, as lead investigator on the case, was not truthful in several different investigations. And the defense says that the investigators wrote up the arrest affidavit very early on in the investigation because they wanted to pin it on the husband from the beginning without looking into the unknown DNA found in Suzanne Morphew's car. Prosecutors say they provided several copies of the discovery to the defense, and the defense isn't entitled to a checklist of everything law enforcement officials have done. Well, Judge Lama, the new judge, says the defense needs to show a need for the information regarding the internal investigation report into Cahill. He says that Barry Morphew has the right to see these materials, so the motion to quash was denied. So what that really means is what I've said all along. The prosecution has to turn everything over, good, bad, and ugly, for the prosecution. And it doesn't sound like they're doing it unless they're absolutely told to do so. And the fact that your lead investigator is at issue is not good, because there's going to be a veracity hearing regarding the arrest warrant. And if you put in information that is exculpatory, that says Mr. Morphew didn't do this, and you take out the information that is not true and correct, the question then remains, is there probable cause? And the prosecution already has a very weak case in this regard, but if it looks like all the people that were involved that are going to have to come and testify are of questionable character, it's not looking good for the prosecution. So Commander Walker from the Chaffee County Sheriff's Office, who was formerly an investigator for the DA's office, did in fact sign the affidavit, but states that he is not aware of the information regarding the DNA that was found in Suzanne Morphew's car, which just happens to go to a registered sex offender in Arizona. That is when Agent Cahill apparently said, "Don't worry, I got this," thinking he's going to check it out. Lots of weird things regarding that DNA for sure. Things that get really weird is a guy by the name of Jeff Lindsay. He was the prosecutor on this case and then abruptly resigned from the district attorney's office in October, and the district attorney's office has not had any contact with him since January 5th. He refuses to cooperate or talk with the defense, and it appears as though he is not responding to subpoenas to appear in court. I wonder why he wouldn't want to testify. Well, we're going to have to wait and see. We'll let you know tomorrow. First, the defense got just about everything they wanted in the Barry Morphew trial. Now, as this thing turned into a circus, I think we're getting really close. First, Barry Morphew was given a little more taste of freedom when the judge granted him a bond modification so that he can visit his daughters who are residing in Gunnison, Colorado. For those of you who may not know, Barry's wife, Suzanne Morphew, vanished on Mother's Day in 2020. Her bike and helmet were found nearby the Morphew home in Chaffee County, but her body was never found. She's now presumed dead by law enforcement, and Barry is the sole suspect, according to law enforcement. He has pled not guilty, and he was able to post a $500,000 bond. Today, Barry Morphew's daughter made a tearful appeal in court, the first time that either of them have spoken publicly about their mother's disappearance and alleged homicide. Mallory Morphew said, "It has been a hard and confusing time, and we've been struggling, grief and sadness. We are a family and we need each other. It would be a blessing for us to be a family together in the town." Over, which is Gunnison. Now, the daughters live in Gunnison, which for reference is a little over an hour from Salida, and say that their work schedules make it very difficult to see their father, who lives obviously there in Salida. The prosecution made no objection to the change. Other terms of the bond will remain in place. He still has to wear the ankle monitor, and he has to live in Chaffee County, and he's not allowed to contact several people who may be called as witnesses during his trial, which is currently scheduled for May of this year. The Morphew family apparently burst into tears upon hearing the good news, and a deputy apparently walked over with a box of tissue to the girls. Now, the new judge on the case, a Judge Lama, also ordered that the prosecution has to provide emails related to discovery that has to be handed over to the Barry Morphew defense team no later than January 31st. Morphew's team argued that the prosecution was at times unresponsive when the defense team requested discovery and information shared on the case, and the judge agreed. As you may recall, Barry's defense team also argued that they want all of the drafts of the 130-page arrest affidavit, that needs to be included, and the judge agreed. The judge also noted that in all his years on the bench and also as a lawyer, he's never seen such a lengthy affidavit, such as the one in Barry Morphew's case. The two-day motion hearing continued, but on the second day, apparently the WebEx was hacked and someone was actually broadcasting it. So the court took down the WebEx and also ordered that nobody could tweet or communicate with anyone outside of the courtroom. So it's been a little difficult getting information, to say the least. I am shocked that somebody was a big enough idiot to hack into the WebEx system and put it on the internet, okay? And to put it on YouTube specifically. I've said this before, and I'll say it again. Whoever did that should probably be held in contempt by the court if they can find out who did it. Don't get me wrong. If there's anyone that would like to live stream it, it would be me. But the reality of it is we cannot. It's a violation of the court's order. And I have told fellow YouTubers, stop streaming that at earlier hearings. You're going to be in violation of a court order and you could be potentially held in contempt. Which is one more thing. As you may recall, the district attorney in this case, a woman by the name of Linda Stanley, the elected DA, went on a podcast, people we consider a friend of ours, Mike King, in Profiling Evil. Well, guess what? The court found that she, the district attorney herself, had violated the court's gag order about talking about this particular case. Not good. Unclear exactly what remedy was asked for. I think the defense team is just going to use it for some cross-examination. The other issue that I'm still trying to get information about is whether the district attorney that resigned back in October, he was supposed to appear, but yesterday seemed to be very elusive and wasn't responsive to either the defense or the prosecution. So it was kind of curious whether he was going to show up. We'll have to wait and see. I think you have to definitely say at this point, the defense is winning as far as scoring little victories. I said this all along. I've never seen a 150-page affidavit for an arrest warrant ever. Frankly, if you take 150 pages to outline why you think a case is supported for a conviction and an arrest warrant, you've got something wrong. Most affidavits, even in a homicide case, guess what? They're usually no more than 2 to 4 pages. 150, yeah, that's just padding the information there. And it looks like, the lead investigator from CBI, who's in charge of the case, that had to resign because of a negligent discharge of his firearm. And during the investigation, CBI determined that he was not truthful. Not good when your lead investigator has, truthfulness issues. Looks like, as I told you, I don't know, we'll never know what's going to happen for sure, but I didn't think the prosecution should have filed this case just yet. I think they jumped the gun. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did. Josh Duggar, that's right, the man's name that rhymes with hugger, the one that is in custody after his conviction and is awaiting sentencing for possession of you know what. That's right, we hold up the sign for those listening at home. The first word begins with C. The second word begins with P. That's right. We're not going to say it because YouTube hates the truth. Anyway, there's been some audio recordings released of the Josh Duggar interview from 2019. Investigators had just uncovered several illicit downloads of holding up the cue card again for those listening at home. And they raided his car dealership. Now, the feds returned to Duggar's car dealership in Springdale, Arkansas, to arrest the 19 kids and counting alum on charges of receipt of the possession of, that's right, holding up the cue card. Photos have also been released of Duggar's messy office where he downloaded the disturbing pictures of minors. Other photos show his HP desktop that he used to search the dark web for those inappropriate pictures. And the background of the computer just so happened to be a wholesome picture of the Duggar family, his wife, and their 7 children. Among the evidence found in the FBI raid on the property was a selfie of Duggar that placed him at the scene on the same day a sales receipt for a vehicle was drawn up and saved behind a secret partition of his work computer that contained the illegal materials. The feds tracked the illegally downloaded items to Duggar via his internet provider, and they raided his wholesale motorcar business where agents persuaded Duggar to speak with them voluntarily. Now, before they had told him anything about their investigation, he blurted out, "Has someone been downloading, those images?" At this point, the officers read Duggar his rights and asked him if they could make an audio recording of the interview. The conversation begins with Duggar telling the feds about what he does for work, calmly saying he owns the dealership and he does some real estate as well. They then asked Duggar if he's familiar with peer-to-peer programs such as Tor browser that can be used to anonymously share music, movies, and other files. The software was created as a legitimate tool to protect privacy, but it's also used by criminals and pedophiles to search for outlawed items on the dark web. His response was, "I'm familiar, I guess you could say," Duggar replies. Asked about how many of his machines have such software downloaded on them, he responded, "Well, probably all of them." After a brief explanation of what kind of investigation the agents specialize in, one of the agents says, "A lot of times we'll find through internet tips that people have, downloaded inappropriate child photographs and things like that." That is when Duggar begins to stumble over his words and pleads for more clues. "Is that what you're saying? Is that what you're saying is going on?" he repeats. Is there something going on my device where that's been something accessed or something is downloaded or uploaded or something like that?" The rambling goes on for a few minutes, actually. The agents then cuts to it and warns Duggar, "That's what you see all these other guys running around doing. They are computer forensic analysts, so even if something's on a computer that someone might have downloaded and then deleted, they're going to be able to find it." The investigator tells Duggar that, quote, "These are somebody's little boys and little girls at the end of the day. Our main objective is to find out who's doing it." Then Duggar nervously replies, I appreciate the work you guys do. Agents then respond that and gives Duggar the opportunity to come clean about anything that will be found on his computer, warning him once we leave here today, it's the end of our conversation. Duggar chose not to cooperate, further anxiously adding, I've watched my friends, answer things and they get them for conspiracy or something. And I'm not a federal statute and are broad and there's a lot of things. And I'm not going to say anything that's going to incriminate me or anything at all. I'm not denying guilt and I'm not saying that, as far as anything goes, I don't want to say the wrong thing. I don't want to say that I'm guilty or not. I'm just saying, searching, finding, accessing inappropriate content at some point, right at any point in my life. And of course, we know, even though Mr. Duggar wasn't exactly very articulate in keeping his mouth shut, of course, we know that the feds had found what they suspected on his desktop computer. He was obviously found guilty and faces up to 20 years of imprisonment and up to a $250,000 fine on each count. Listen to the audio, ladies and gentlemen. Certainly nobody's condoning what he was convicted of, but it's a good example of why you simply say, lawyer, 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 because, God, that just sounds guilty, doesn't it? There was a hearing in the Chad Daybell matter. Now, what usually happens in the Lori Vallow Chad Daybell matters? Well, usually we have a hearing to request a hearing for another hearing. And guess what? You will not be disappointed. We put the video up today, and today was a hearing regarding the motion to continue the filing of 12B6 motions. Well, what is a 12B6 motion? It is basically a motion to dismiss for some sort of defect in the pleading. And here, document is the indictment, which you have to say that there was some sort of structural defect with the grand jury proceedings, like maybe there wasn't a quorum, maybe somebody was allowed into the proceedings when they shouldn't have been permitted. Was there an actual vote? Was there enough of people in a quorum to actually hold a vote? Those types of issues that take place. That would be a 12B6 motion. These are normally due within 28 days after arraignment. Well, Chad Daybell entered a plea of not guilty back in June. His motions would have been due in July. Well, there were motions to extend the 12B date, I think in August as well as September, because of delays in the preparation of the grand jury transcripts. Fine, the court does that. Well, here we are. John Pryor, the attorney for Chad Daybell, gives a explanation and basically says, Judge, there's no excusable neglect issue here. I've been very diligent. I've been trying to get these grand jury transcripts. It took longer than expected, and there were 5 days of transcripts. Ladies and gentlemen, that is not that long, okay? Think about it. Appellate attorneys look at transcripts from hearings for trials that go for weeks, as well as prior motions hearings. 5 days of a transcript is not that voluminous. And then John Pryor stated to the court that he had to go back and then look at the transcript for the preliminary hearing to see if there were any issues that had to take place, for inconsistencies. Not sure what that has to do with the 12B6 motion at all, but needless to say, Judge Boyce granted John Pryor additional time. There's going to be a hearing on March 23rd at 9 a.m. regarding the motion for 12B6, if there is one that is filed by the filing deadline, which is March 9th of this year. I understand the attorney has to do his job and he needs to preserve any issues that exist. The prosecutor in this case, Mr. Wood, actually did a very good job saying, Judge, he hasn't done anything. He hasn't been diligent. And the court said, well, we don't have a trial date until next year. That's right, 2023. So what's the harm? We'll let him do it, but you better have something filed by then. John Pryor said he would. We'll see. He seems to always have a problem in getting something filed on time. And even when he does file something, it is a little thin on facts and the law. We'll see if something gets a little better on this particular moment. But yes, another delay in the Chad Daybell matter. I get trial is a year out, but the sooner the issues are framed, which means the judge needs to set hard deadlines so that legal issues can be resolved, that will help frame the case and it oftentimes leads to resolution. When the unknown exists and you don't know what's coming in and what's going to be not admitted into evidence, well, that doesn't create decisiveness. Indecisiveness creates uncertainty. You can't have that. You need decisions made so that people have decisions to make. They need deadlines so that they can actually comply with those deadlines, because deadlines, ladies and gentlemen, force decisions. We've all heard the old adage, the job expands to the amount of time given. So if the court were to impose deadlines, and if you miss those deadlines, guess what? You actually comply. And I don't know what's going on in the legal world once, because I remember I filed a motion once. I complied with the court order on a post-conviction matter, and the court thanked me for filing the motion on time, and I was looking at her rather perplexed, and I'm like, well, of course I would file it on time, Your Honor, because that was the deadline that you set. She goes, oh, you'd be surprised. People miss deadlines. They ask for more time all the time. I'm like, well, I'm a firm believer in let's get it done. Judge Boyce should adopt an attitude of we're going to get this done so we can get this case done. Let's get to the docket. First, Alec Murdaugh is back in the news. $65 million man, potentially. The mother of the 19-year-old Mallory Beach, who was killed in a boat crash in 2019, as well as two survivors of the accident, are seeking a combined $65 million in claims against the estate of Maggie Murdaugh and her son Paul, who was allegedly driving the boat while intoxicated. Now, Mark Tinsley, the attorney for Renee Beach, filed two $25 million creditor claims in Colton County probate court against the estate of Maggie Murdaugh and Paul Murdaugh, who were obviously, we talked about, shot dead on their hunting property back in June of 2021. Tinsley said he filed the claims to make sure his clients are in line to get money they believe is owed to them before any other beneficiaries of the estate. Tinsley also filed personal injury claims for Morgan Dowdy and Miley Altum, who survived the boat crash, against the two estates from the boat crash, according to documents. Now, Dowdy, Paul's girlfriend at the time of the accident, filed two $5 million creditor claims against the estate. Altman, who is dating Paul's friend Connor Cook, filed $2.5 million creditor claims against the estate before Paul and Maggie were murdered. Now, Mallory Beach's family, as well as survivors Connor and Anthony Cook, had filed civil lawsuits against Murdaugh back in connection with the boat crash as well. Tinsley says the claims were filed as a place-holding mechanism to ensure that money from the estate is not distributed to beneficiaries before the creditors. Some of the beneficiaries obviously could be Alex Murdaugh. Tinsley said he believes Murdaugh and his brother, John Marvin Murdaugh, who represent Maggie's estate, are taking preemptive legal measures to protect properties, including the family's 1,700-acre estate, from creditors. In 2021, a judge placed a lis pendens on the property owned by Murdaugh. Now, lis pendens is simply a document saying this property is subject to litigation, and you don't want to buy it until that litigation is resolved. It essentially freezes the assets to prevent them from liquidating assets. Now, recently, John Marvin had asked the courts to remove the lis pendens on the properties in Maggie's estates, which are supposed to go to Alec. Funny how that works, isn't it? His attorneys argued that the Beach family has no claim to continue against the estate. We'll have to see how that works out. Everybody's lining up to get money. And I get it. These are all tragedies, but I said it once and I'll say it again, ladies and gentlemen. At the end of the day, it's about the money. And when they say it's not about the money, guess what? Then you know it's really about the money. Thanks for watching. We'll see you next time.